Intellectual property rights, a double-edged sword. The Standard Business Dictionary defines intellectual property rights (IPR) as a right that is had by a person or by a company to have exclusive rights to use its own plans, ideas, or other intangible assets without the worry of competition for a specified period of time. The most well-known types of IPR include copyrights, patents, and trademarks. In this video, we will discuss the perceived merits and demerits of IPR and talk about whether they are a means to deny access to knowledge or preserve the sanctity of that very access. The extent of rigidity of IPR laws has been and continues to be a highly debated topic, and the delicate nature and contentiousness of the subject has so far hindered a decisive conclusion. Empirical evidence as to the role of IP protection in prompting innovation and growth remains inconclusive. Diverging views also persist on the impacts of IPRs on development prospects. Several questions have arisen over time: where to draw the line, how to formulate laws which are both author and user friendly, how to protect the exclusivity of original content, thus incentivizing originality and creativity, and at the same time ensure a widespread impact of the same on the masses in a way that the objectives of both the creator and his audience are satisfied. Striking the balance is a multi-pronged procedure which requires the amalgamation of several philosophical and legal discourses. Like most other things in the world, the conclusion regarding IPR is also neither black nor white, rather a never-ending shade of grey. Arguing for or against the sensitive issue of intellectual property rights is a tricky affair, for it has no simple binary answer. Ideally, the intention behind the implementation of intellectual property rights laws was never to deny access to information to anyone. Creativity and innovation, whether artistic, scientific, or intellectual, is of high social value in all spheres of life. All IPR aims to do is to monetize this value and incentivize more original content. At its core, it is the interests of the innovators or artists that stand to be protected. This is because incentive to create is not always an altruistic one. The promise of a reward, both in monetary and non-monetary terms, is a major driving force behind any innovation. The IPR practices therefore do not wish to bar access to information, but simply to set up an attached economic benefit with it and rewards its rightful owner. The need for strict IPR laws have become more and more apparent, especially now with the advent of the internet age, where information is currency. In the ever-increasing networks of World Wide Web, plagiarism has become facile and undetectable, and it is very easy to rip off original content. Owing to the intangible nature of intellectuality, the protection of intellectual property is a rather difficult job, much more difficult than protecting physical property. Any piece of intellectual property has an infinite number of uses. A producer of information or an intellectual good can usually do very little to stop their first buyer from replicating it and selling it at a low price. For example, a film or a song, which possesses value in the form of public entertainment, can be rewatched and listened to over and over again to derive utility. What IPR does is ensure a fee on a per person or per use basis, which is credited to the creator. Moreover, it also makes sure that no one else is illegally profiting off of the work. The reasons behind the implementation of IPR can be broadly classified into three parts. They provide financial incentive to innovators and creators by giving them monetary benefits. The guarantee of maintenance of exclusivity on an original work of art or science serves as the strongest incentive to content creators. Be it a song, poem, essay, or a technological invention. The assurance of its protection from illegal copies and unsolicited credit sharing takeovers result in a sense of security for the author. They ensure economic growth. A large percentage of any economy's assets comprise or who are in some way related to intellectual property assets. IPR laws ensure the protection of these assets. Without protection of ideas, businesses, and individuals would not reap the full benefits of their inventions and would focus less on research and development. Finally, the safeguard morality. Enforcing IPR laws secures the rights of any original work to its author and doesn't allow other people to profit from it. The provision of the penalization of plagiarism is necessary for stimulating and protecting creative content. Quoting Hegel, the German philosopher said, "Every man has the right to turn his will upon a thing or make the thing an object of his will. That is to say, to set aside the mere thing and recreate it as his own." IPRs are thus merely instruments of protection of this will. But coming to the inevitable flip side now, what represents a central problem in these discourses is the indivisibility of intellectual property. Unlike material property, where ownership and usage is restricted to an individual or a group of individuals, an unlimited number of people can consume an intellectual good without it being depleted. Complications arise out of the regulation of the extent of this consumption, owing to the inefficiencies of regulating bodies and their inherent corruptibility. Most of the IPR laws do not hold up under scrutiny and lead to a highly skewed and ownership and preferential system of IPR granting, which results in a number of negative consequences on the ownership of information, such as retarding of innovation and exploitation of poor countries. This becomes a strong argument against stringent copywriting law. For instance, in 1980, a book entitled Documents on Australian Defence and Foreign Policy 1968 to 1975 was published by George Munster and Richard Walsh. It exposed several government dealings, memos, and other documents which served as incriminating evidence of linking the involvement of the Australian government in the Vietnam War and other issues. Reproduction of such sensitive material wasn't taken lightly by the administration, and in an unprecedented move, an interim injunction was issued citing both the Crimes Act and the Copyright Act. The book, which was released mere days ago, was put off sale along with any subsequent media coverage or print ads. This example illustrates how IPRs can be used to protect the interests of those in power, even if it blatantly disregards the fundamental rights of ordinary citizens. Governments generate information in plentiful population statistics, growth rate data, unemployment figures, etc. The generation of this information is paid for through taxation, and therefore it might seem that it should be available to any member of the public. But in some cases, this information is privatized and sold to corporations with significant sway in the market, and money power or simply retained by the government by citing a copyright law. This reduces transparency of the administration process. Copyrights thus can also serve as a legal provision to governments or other powerful organizations to withhold or manipulate information that rightfully belongs to the common masses and yet be justified on legal grounds. Further arguments against IPR laws can be summed up via the points put forward by the A2K movement. The access to knowledge, that is A2K movement, is a loose collection of civil society groups, governments, and individuals converging on the idea that access to knowledge should be linked to fundamental principles of justice, freedom, and economic development. The A2K Treaty is a proposed treaty which aims at easing the transfer of knowledge to developing nations and to make sure that the open innovation systems are viable all over the world. One of their arguments in favor of their fight against certain IPR practices is the concept of rights delayed is rights denied. For instance, 3 million children would have died if access to oral rehydration therapy and second-generation vaccine technologies had been delayed for 20 years. Even for less life and death inventions, something like a 20-year delay serves as a huge impediment to the potential beneficiaries of the rights. For cultural works, protection lasts longer than a generation almost, which seriously harms society as a whole. It puts a stop to cultural exchange and diversification, and in the long run can even result in the loss of cultural capital. It makes much more sense for content creators to cooperate and collaborate to boost efficiency and creativity of society as a whole. So, does a solution lie in scraping all intellectual property rights and let the world return to one of expected harmony and cooperation? Probably not. Such a venture is a lot easier said than done in the dishonest, unscrupulous world that we live in. There can be, of course, counter-arguments to these statements and further counters of those counter-arguments, resulting in somewhat of an infinite loop. Regardless of that, an ideal model should be somewhat along the lines of one which ensures protection of original content and encourages creativity while warranting an optimum level of distribution of intellectual property as well. The goal is to keep striving towards the equilibrium.